Good afternoon, my name is Ronaldo Hilton, Chairperson Designee of the New York City Loft Board. Welcome to our March 21st, 2019 public meeting. Section 282 of the New York State Multiple Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversion of interim multiple dwelling buildings from commercial and manufacturing spaces to safe rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multiple Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the Loft Law and the Loft Board rules. We will first turn our attention to the vote of the January 31st, 2019 minutes. Are there any corrections or comments to these minutes? Do we have a motion to accept the minutes? Can't see. Mr. Bowers. Is there a second? Ms. Torres. Ms. Rivera.
Mr. Carver.
I was absent. Abstaining.
Mr. Barrett.
Yes.
Mr. Roche.
Yes.
Mr. Delaney.
Yes.
Ms. Torres.
Yes.
Ms. Rosen.
Yes.
Chairperson Hilton.
Yeah.
6 in favor, 1 abstain, 2 absent.
Thank you, Ms. Rivera. We turn next to the minutes of the February 21st, 2019 board meeting. Are there any corrections or comments in those minutes?
Mr. Chairman, I'd just like for the record to be modified to show that the fire department was here. I was here. Unfortunately, because the meeting didn't start until about an hour and 15 minutes behind schedule, I had to leave to get to a family funeral function.
So noted. Minutes will be changed to reflect the presence of the fire department. Any other comments on the minutes?
Mr. Hernandez was here as well, and Mr. Delaney pointed out that on the page 1, where we're talking about the transcripts of the decisions, it's kind of not clear. So, it's the 5th quote down, where I say, no, those decisions from the bench, where there's a transcript, and we haven't gotten those yet, but I'll follow up with the law department. So we haven't gotten transcripts yet. We want to make it clear. It will not be written decisions, but we'll circulate the transcripts. What have you received?
Rather than where there is a transcript, did you mean but there's a transcript?
No, what I was saying is those are decisions from the bench,
Right.
where there's a transcript, right? Instead of a written decision, there is a transcript. So I can change it to but if you feel
No.
strongly about it.
No.
So what are you exactly changing?
So it would be no, those were decisions from the bench where there's a transcript, and we haven't gotten the transcripts yet, but I'll follow up with the law department, and then the next line would be Ms. Paulson further confirmed that there will not be written decisions, but she will circulate the transcripts.
Those changes were made. Any other comments on the minutes? Mr. Delaney.
I see we have minutes from the 21st. Pardon?
Okay, go ahead.
Yeah, I see we have minutes from the 21st. Will there be minutes from the February 14th?
Yes, there will be. Unfortunately, we had a miscommunication between staff as to who was responsible for typing those up. So, and we did not realize that in time to get the minutes to you for today, but they are being worked on as we speak.
Okay, and at the, I just want to follow up. At the last meeting, I had asked a question about the project guidelines and whether or not those were public documents.
So the project guidelines will be public documents once the project guidelines are finalized. So I think the question you had was whether or not you could take comments and make them public comments. What was the question, right?
Yes.
So no, so that's not. That is only between reviewers and the department.
So the comments are not public documents?
No.
And they will not become public documents when the guidelines.
Not at all, but they're department records, they're protected, but they're not public. But the final product will be public. I'm sorry, a motion to, any other comments on the minutes of the February 21st meeting? No. So we will take a motion to accept the minutes of February 21st. Mr. Roche, any second? Mr. Carver? Ms. Rivera?
Mr. Carver?
Yes.
Mr. Roberts?
Yes.
Mr. Roach?
Yes.
Mr. Delaney?
Yes.
Ms. Torres?
Yes.
Ms. Grossman?
Yes.
Chairperson Henson?
Yes.
7 in favor, 2 absent.
Thank you, Mr. Rivera. Ms. Balsam will now give her executive director's report.
So the first announcement is a personnel issue, and it causes me great pain to say this, but Mr. Bobick has decided that he is moving on, and this will be his last Loft board meeting. So we will definitely miss him very, very much.
Where's the going away party?
It'll be right here.
Details to
Next-
follow.
Next board meeting.
All right, that's what I want to do.
Yes, absolutely. We're going to miss Mr. Bobby. He's a very hard worker and very conscientious worker. Sorry you have to go.
The amendments to the Loft law are still pending. I'm getting emails all of the time, so new drafts, new drafts, new drafts. So people in Albany are still working on things. The city council oversight has been rescheduled to April, but we still do not have the new date, but I will keep you posted if we get a new date, when we get a new date. The unofficial revenue for January 2019 was $88,511. January, oh, that should say February, sorry. The unofficial revenue for February was $88,511. And we received 3 new lawsuits. The first is Frank Hughes versus New York City Loft Board and DASA Realty. This is the residential occupant where we covered the unit but didn't cover Mr. Hughes because Mr. Hughes testified he was not living in the unit. The second case is Thomas Brigham versus New York City Loft Board, DOB, and B. Jaffe Real Estate Company, LP. This is the case where the board found that the landlord unreasonably interfered with Mr. Brigham's use of his unit as to having him out for an extended period of time, but Mr. Brigham made other claims about sheetrock on the west wall, etc., and dust and debris, which the board said was not unreasonable interference, so he has commenced the lawsuit. And finally, we have Mr. Googleman versus the New York City Loft Board, Cynthia Lamb and Frank Lamb. This is the window case where we found that there were not 3 units, only 2 out of the 3 units for which there was residential occupancy proved that there were qualifying windows. So those are the 3 lawsuits. We have been working on our enforcement plan, and Ms. Lavelle will bring you up to date on that, including going to oath and taking some other steps. She'll give you more of those details, but before she comes up to give her report, does anybody have any comments or questions?
Yes, I don't think my mic works, but
Push your button down.
I know, but I always have the, oh, you got it.
I figured out last time.
Thank you. I did want to make one comment. The last time we reviewed cases was February, so just for the public, when we review cases, we're looking at a proposed order and backup information only, but as a matter of course with Department of Buildings and being an architect, she's an architect, we're always working with looking at DOB biz and checking for violations, or, you know, I'm doing it as a matter of course in my private business. So after I vote on a case, I thought I might want to check on projects and see if I noticed something. So I noticed something with the February cases with self-certing. Self-certing is something architects can do. I do it sometimes when the project's simple. Self-cert on a loft law, I'm questioning whether that's too complex of a project for an architect to be able to self-cert on. And I would like the loft law staff to talk to Department of Buildings about some of the cases that were in February that were self-certed and just check on that. Thank you.
I ask you specifically about the cases you will come to us like after and talk to us about those particular cases that you're
Sure, I
asking
could
us
do
to
that.
look at? Sure.
But always after.
After the vote, right.
Mr. Delaney.
Two things. Number one, I'd like to get copies of the papers and those three articles.
Sure.
And secondly, I think the issue of self-certification is an interesting one, and perhaps it would be beneficial for the board to schedule a general discussion of when self-certification is permitted during the legalization process for IMDs, without it being tied to an individual case.
We saw one in general. So you want a broader, so separately though from her current request, you're asking for a more broader analysis or presentation explaining when self-cert is normally.
Yeah, I think it'd be helpful for a lot of us if the board could provide us with either the board's interpretation or the Department of Buildings policy.
It would have to be the Department of Buildings. So the Department of Buildings policy on self-certs in loft buildings and then.
Yes, I'd like to suggest that as an agenda item sometime.
Does DOB have a policy
On self-certification?
in loft buildings?
I don't believe there's a policy carving out loft buildings. There's a general policy on self-certs.
If the architect self-certifies a building, there's nobody in the city that reviews the self-certification.
There are audits.
Well, self-search or self-search, right? Yes, thank you. There are audits. There are selected audits.
But no, the answer is no.
The answer is?
The answer is no. So you sign something that says, I, as a professional, certify that that this project meets all codes, regulations of the city, the state, and all
And that's the end.
applicable jurisdictions.
And that's the end of it.
Well,
Correct. You
unless-
sign
unless-
everything unless you're audited.
Unless you're audited. So I'm just saying that usually, generally, self-certs are not allowed on authoritative type 1, which are usually the conversion, the whole legalization filing of building. So, but sometimes with that comes all, I don't want to kind of go into policy right now, but because I don't really want to be misquoted. So let's get it together and come back to a proper.
Yeah, my suggestion is to put it on an agenda.
Yeah.
Any other questions or comments on the report?
Okay. Ms. Lavelle, would you please present the enforcement plan?
So last time I presented, I think it was at the end of the year meeting, and the presentation was essentially telling you what we had worked in the pipeline and what we actually did. So just to recap, if you look at the little outline I provided to the board, you'll see that in terms of the reasonable necessary action enforcement measures, again, just to recap, we selected for that specific purpose of inducing owners or encouraging owners to move forward towards legalization. We selected 22 buildings, and that ran across 5 different categories. Again, to recap, it's the buildings owners who didn't file any Alt-1 application, no Alt-1 alteration application. Building owners who did file an Alt-1 application but failed to move forward, meaning start with the narrative statement process and didn't receive Loft Board certification. Then we also selected 5 buildings that had expired alteration type 1 permits, another 5 buildings who had expired TCOs, and and then 6 buildings, and these were all the buildings who actually already had their final certificate of occupancy, but did not file a removal application to have the building removed from the Loft Board jurisdiction. So that's where we get the 22. And again, just for reference, we selected the oldest buildings, meaning that they've been with the Loft Board for the oldest amount of time, and just kind of went down the list. So in each letter we sent, the different owners received different letters depending on which category they were in, and then each one had a call to action. So in terms of getting compliance or getting responses from owner, this is the breakdown. So we received six letters from owners and architects. About 2 owners essentially stated in their letters and provided information that they in fact hired architects, and these were building owners who at first did not file one application, so it was moving towards the right direction. We also received 3 letters from architects, and these were the buildings in the expired temporary certificate of occupancy group, and essentially they were explaining the reasons why they were delayed and what the next steps would be to renew the TCO. And then we also received just 1 letter from another owner, but that wasn't really telling in terms of why they were stagnant in their legalization phase. In terms of affirmative steps, so these are building owners who actually took action and progressed towards the legalization phase, which is what we want. We saw about 2 buildings who were in the expired permit stage. They actually obtained temporary certificates of occupancy. And then we also had 2 building owners who were in the final C of O phase but didn't file a removal application, actually filed removal applications with the Loft Board. So again, they're progressing in the right direction. In terms of upcoming enforcement measures, the goal is to start action against the owners who have not either made significant headway or had not contacted us. So moving forward, we're going to be issuing 7 notices of proceedings. So essentially, these are the notices of proceedings which does not require a hearing. So we're not required to present a case before oath, but essentially just lays out that you are in this stage, you failed to meet this deadline by this date, and that we are likely to pursue fines against you. So we'll be issuing those as soon as possible. And then just so you know the breakdown, so the buildings who are in this different stages who are going to receive these notice of proceedings will be about 3 buildings who did not file an alteration application, type 1 application, who didn't file one at all. And then we have 2 buildings who have the expired permits. And then we have 2 buildings left over in the expired temporary certificate of occupancy group that will be issuing these notices of proceedings with. And then I think, oh, and then also in terms of, there's 1 building left who was in an expired permit phase. They did make some headway. They actually renewed their plumbing alteration type 1 permit, but it seems like they're still, it's not unclear about what their next step is, so we're going to bring them in to do a legalization conference so we can get an idea of what is going on and if we can provide any insight for how they should move forward. And then for the buildings who have again, the final C of O or residential certificate of occupancy, but they have not yet filed a removal application, the Loft Board will just initiate those removal applications on our own if they have not filed them. In terms of litigation, when I last presented, I know I mentioned housing maintenance prosecutions. We have started those. We actually have 2 buildings that we are prosecuting before oath. They're still pending. And the first building, you will see we issued 5 violations, and those stem from complaints and confirmation that the owner allegedly did not provide gas supply, failure to provide heat, hot water, failure to provide adequate heat, and water supply. So those were the bases for us commencing action against this building owner for these 5 violations. And we actually had a settlement conference just on March 8th, which was a Friday. And then for the second building, is another housing maintenance violation. It's just for 1 violation that was issued, and it was issued for failure to provide adequate heat. Again, we're still in litigation, and we actually had a settlement conference again just last Friday on the 15th. And for those 2, we do have another appearance scheduled for both cases.
For those buildings that we issued a violation, have you seen any, has there been any response?
For the housing maintenance or?
Yeah, housing one. Yes.
So, well, yes, so in terms of, because it is pending litigation, I'm just concern ourselves.
Yeah, so let me answer that. If they had cured, we would not be at oath.
Okay, so.
Yes.
Okay, so let's withdraw that, not cure. So they haven't made any, can she comment on if they've made any further steps to correct?
That's an issue. That's going to be decided by the board judge, so no.
I have a question. In the housing maintenance cases, what is the specific remedy that oath that you seek at oath?
So when we issued the summons and notice a statement of charges, essentially we're looking for, we always, goal is to always have a cure, but imposition of a fine. And for each one of the violations of the max, I believe that the violation of time elapsed, that the max should be the $17,500.
So of the 22 buildings, you got like some action from about 10 of them. And the letters from the owners and architects, was I correct that those are mostly relating to TCO and CO? So
that's right.
Those are the people who have been more better.
Correct.
Compliant.
Correct.
And the ones who aren't so good, they're like not moving quite
correct
as fast. I see. The address for these 22 buildings would be public record, I suppose.
Yeah, I created a spreadsheet so we can keep track of which buildings that are a part of this
Good.
test.
Could I ask for a copy of that spreadsheet?
Yeah, sure.
Thank you. And I remember when we, first off, I think it's great to see that we formulated an enforcement effort and we're embarking on the enforcement effort. And I know there was some concern expressed as to whether we had the bandwidth to do this, but are you finding this a big component of your time? Or?
It is somewhat, especially because if you can imagine, a lot of the times we have to create new templates, kind of figure out, work out the legal logistics on how we're going to create templates and accusatory instruments to kind of start these cases before oath. But once that process is laid out, it should be smooth sailing. So it was a lot of time up front, but I think now that we have these two cases and we're feeling our way through, it should pick up if we need to for the prosecution.
Great. Congratulations.
Thank you.
To the staff.
We worked hard.
Thank you. Any other questions? No, thank you. Appreciate it. Good work. So this summer calendar, there are 5 proposed orders for 6 cases on the summer calendar. They're usually voted on as a group. But however, hold on. At this time, we're going to parcel out 3 of the cases to be voted on separately. But the first two cases which we voted on as a group are Amelia Broad Street at 22 Catherine Street in Manhattan. Docket numbers are PO 0048 and TA 0239. Also 55-65 South 11th Street tenants at 47-65 South 11th Street, Brooklyn. TR 0829. Is there a motion to accept?
Mr. Chairman, just to correct, I asked that cases 2 and 3 be voted on.
Oh, I'm sorry. I thought we had other cases. I'm sorry. Thank you, Mr. Delaney. Therefore, we'll also include the last case, number 5, tenants of 28 Locust Street, Brooklyn, TR 1272. Those 3 cases will be voted on as a group at this time. Is there a motion to accept these 3 cases? Mr. Carver, is there a second? Mr. Barnes.
Mr. Carter?
Yes.
Mr. Barber?
Yes.
Mr. Roach?
Yes.
Mr. Delaney?
Yes.
Mrs. Torres?
Yes.
Ms. Roseman?
Yes.
Chairperson Henson?
Yes.
7 in favor, 2 absent.
Thank you, Mr. Rubin. Apologize, I should have asked if there are comments in these cases, but obviously there was none. All right, the next two cases that are voted on in this group will be Pamela and Christopher Brown at 255 18th Street in Brooklyn, docket number TA0230, and attendance of 255 18th Street. The address is 255 18th Street in Brooklyn, and that docket number is TM0091. Is there a motion to accept these two cases? Mr. Carver, is there a second? Mr. Marvelous, thank you. Are there any comments on these cases?
I would just comment that I asked that these be taken up separately because I intend to vote no. I elaborated on my reasoning at the board meeting in February, so I won't go into great detail, but I am opposed to settlements where the Loft Board is left to neither accept nor reject the terms of the stipulation. I think it has the danger of eroding the rights that accrue to tenants who are protected under the Loft law, and adds to confusion as to what is enforceable, what's not enforceable, and for that reason I plan to vote no on these two cases.
Thank you, Mr. Delaney. Are there any other comments on these cases? Ms. Rivera?
Mr. Carver?
Yes.
Mr. Barber?
Abstain.
Mr. Roach?
Yes.
Mr. Delaney?
No.
Ms. Torres?
Abstain?
Ms. Roseman?
Abstain.
Chairperson Henson?
Yes.
3 in favor, 1 against, 3 abstain, and 2 absent.
So this motion is not passed for those two cases. The master calendar cases, there are two cases in the master calendar. The first case is Andrew Ohanesian. At address is 473 to 493 Kent Avenue in Brooklyn. The docket number is TM0093. Mr. Clark, you will present this case.
Thank you, Chairperson Hilton, board members. On April 20th, 2017, the tenant of Unit 709 filed an application seeking a finding of diminution of services. The application is based on owner's attempt to bar tenant from parking his vehicle in the space tenant used since 2009. Pursuant to 29 RCNY Section 2-04C, there must not be any diminution of services. Owner argues that tenant's application should be denied based on 3 grounds. First, owner argues it did not prohibit tenant from parking in the space, and therefore the application is premature. However, owner's repeated demands that tenants cease use of the space creates a controversy that the Loft Board can decide on the merits. Second, owner argues that tenant's use of the space does not constitute a service that owner is required to provide because the space is not a building-wide amenity provided to all tenants, nor does the space adjoin to a specific unit. However, nothing in the Loft Board rules or case law requires services pursuant to 2-04C to be provided to all tenants or adjoin a specific unit. Finally, owner argues tenant waived his right to the space. However, tenant continued to park in the space. Tenant continued to send rent checks for the space even when they were rejected by owner. Tenant placed a boot on his vehicle to prevent owner from towing it. And tenant filed a claim with the Loft Board for diminution of services. Tenant's actions do not support a finding of a waiver by tenant, and there is nothing in the record that supports owner's position that tenant waived his right. The record establishes that there was a mutual agreement for the parking space between tenant and prior owner. Owner's attempt to bar tenants' use of the area for parking constitutes a diminution of services. The proposed order before you today grants the application and directs owner to cease all efforts to bar tenants' use of the area currently used for parking.
Thank you, Mr. Clark. Is there a motion to accept this case? Mr. Delaney, is there a second? Mr. Bowers, any comments on this case?
Yes, I have some comments. I'm going to be voting no. I believe parking is not a service contemplated by the rule that is required to be maintained because parking is completely outside the operation of the building. Furthermore, parking bears no relationship to the goals of the statute, which is to address a housing crisis by legalizing certain living spaces being occupied illegally. It makes no sense to require an owner to expend resources on parking that could otherwise be used towards legalizing the unit. So I'll be voting no on this case.
Is there any other comments on this case?
Yes, I would encourage my colleagues on the board to vote yes in this case. It was the subject of considerable discussion in the private meeting. And I believe this is the first time this issue has come to the board. But I also think it's analogous to issues that we've dealt with and found diminution in cases of access to the roof, access to storage in the basement, and I think our action here is consistent with with what we've established in the past with regard to diminution of services.
Thank you, Mr. Delaney. Any other comments?
I guess maybe I would just add that I noticed that it's a vehicle that's used for moving art. The tenants and artist who counts on this as a way to move their large pieces of art. So for me as a business owner in a live-work situation, I can understand that it actually affects the small business side as well as the residential. So I just wanted to point that out. The parking space represents more than just someone having a residential car in a city that has lots of subways.
Thank you, Mr. Rowe.
Mr. Chairman, I'm going to vote no on this case also, based on the fact that we had some discussion again in the private session that perhaps we should research some case law in this situation. As my colleague said, we believe this may be the very first time that we've ever dealt with a parking space issue as the Loft Board. May or may not be factual, but there was enough concern that additional information would be helpful before making a determination.
Mr. Chairman, in response to Julie's remark, there have been cases in the past where sculptors using heavy material, making lots of noises, have been also barred by the landlord because of the noise, and we certainly have certified artists, sculptors living in spaces. So in some ways, this is analogous to that, so I'm going to vote positive on this case.
I happen to think that parking is an accessory to residential living. So, yeah. So, is it any more comments on this?
I'll make the comment that I agree. It's part of the building, as all parts of the building are part of the building. I find it unfortunate that this one in particular is our first one because it's parking in a loading dock, which speaks to actually code. All of these comments that we're potentially trading one diminution of service for another. So by taking away the parking from the applicant, we are affecting him, but by voting to allow the parking, we're potentially affecting the other tenants access to loading and unloading using the loading dock. So I think this is a really finicky, potentially finicky one and tough one, and that's my comment.
Thank you. So, Ms. Rivera?
Mr. Carver,
No?
Mr. Barrett,
Yes.
Mr. Rouge,
No.
Mr. Delane,
Yes.
Ms. Torres,
Yes.
Ms. Roseman,
Yes.
Chairperson Hudson.
Yes.
5 in favor, 2 against, 2 absent.
Thank you, Ms. Rivera. The second case on the master calendar is 400 South 2nd Street tenants. 400 South 2nd Street in Brooklyn. The docket number is TR1269, and Mr. Barak will present this case. Is your last case presented? Yes.
You may change his mind.
Thank you. Yes, I
Let the record reflect that Mr. Barak may change his mind.
This is a tenant-initiated coverage application pursuant to MDL 2815 and protected occupant status. Prior to trial, tenants and owners stipulated to most of the eligibility requirements of MDL 2815. The only issues before the board are whether the building was occupied for residential purposes by 3 or more families living independently for 12 consecutive months during the relevant window period, and 2, whether tenants are protected occupants. The report recommends a finding that the building is an IMD pursuant to MDL 2815 with 8 IMD units. Second, the report recommends denial of Article 7C coverage for units 303 and 405 because tenants could not demonstrate that these 2 units were residentially occupied for 12 consecutive months during the window period. Lastly, the report recommends protected occupant status to the occupants of the 8 IMD units. Staff agrees. Based on the credible and unrebutted testimony of tenants and their non-interested witnesses and the extensive documentary evidence in the record, units 205, 204, 205, 301, 302, 304, 402, 403, and 406 were all residentially occupied for 12 consecutive months during the window period. With respect to units 303 and 405, the record shows that Ms. Junick moved into Unit 303 in December 2009, and Mr. Verma moved into Unit 405 in November 2009. Therefore, they had to prove residential occupancy of 12 consecutive months by someone else prior to their occupancies. However, tenants failed to do so. Tenants did not provide details as to who lived in these units prior to the start of their occupancies, nor did tenants prove how long the prior residential occupancies lasted. The report also recommends a finding that the occupants of the 8 covered units are the protected occupants of their respective units. For these reasons, the proposed order before you grants coverage to the building and 8 IMD units and grants protected occupant status to the occupants of these 8 units. Thank you.
Thank you, Mr. Barak.
Chair. I don't know what order we want to take this in.
I was going to say that in the prior session, we did understand that there would be a motion on this particular.
Yes.
Mr.
I am not persuaded by the reasoning of the ALJ with regard to the 2 units that are found not to be covered. There was testimony in the record that both of these units had been used residentially since the early 2000s. While there was a period where there appeared to have been a variety of subtenants during some of the window period, both the applicant for 303 and the applicant for 405 moved in at the tail end of the window period. This building obviously had a little bit of a complicated history. There was a month-long vacate in September through sometime in October of 2009. The testimony of the former residential occupants of those units was not found to be not credible, and I therefore would propose that we modify the order to include finding coverage for units 303 and 405.
You're making the motion then?
Yes.
Could you just make that motion?
Sure, I move that we modify the proposed order to find that units 303 and 405 were residentially occupied and that the applicant should be named protected occupants of those two units.
Is there a second on that motion? Just clarify, you want to clarify what he's asking?
Yeah.
So Ms. Delaney is asking, is making a motion that this order be modified, what unit numbers are there?
303 and 405.
303 and 405, that the order be modified to include those two units as covered under this order. Do we have a second under the motion?
Just the units covered, or the units
No,
covered
and
the
protection.
occupants?
Correct.
Can those two, can they be separated? I mean, I know that's not what your motion is, but
You
Question
can't
on the
have, you
motion.
can't have protected occupancy without coverage. You
But
can have
you can
coverage
have
without
coverage.
protected occupancy, but you can't have protected occupancy without coverage. So you have to do the coverage first, and then get to the protected occupancy.
but the way this has been presented, we're voting on both at the same time.
So the motion,
Correct.
Ms. Delaney, 1 second, does the motion include protection?
My proposed motion does.
So, I'm sorry, so let's just clarify the motion.
If it lacks a second, I will be prepared to make a second motion.
So let's just do it in one. So the motion it would be to include those two units as covered and the occupants protected. Is there anyone?
All right, to make that clear, it is vote yes. You restate that,
You would second the motion, or?
yeah, but if you want to, I think you should withdraw your original motion, make a second motion where you will cover the other tenants in the building, so they don't,
Okay, so
they don't suffer. this.
Sorry, if I was unclear. My motion would be to acknowledge the units that the hearing officer found to be
All right.
residentially
Okay.
occupied and
Okay.
named protected occupants, and add these two units, which have a clear history, in my view, of residential use for over a decade, and where there are people in place who have been paying rent, and to find those two units covered and to name those two individuals as protected occupants.
all in one motion. Is there a second? Mr. Barnes.
Mr. Carter?
Question?
You didn't answer comments.
I'm sorry, comments on that particular motion, yes.
So I'll be voting no because I believe that, based on the record, there's no basis for this motion, that the oath judge was correct.
Any other comments?
Mr. Chairman,
Yes.
I'm going to vote no on this also, but it's certainly not because I don't want to see those other two tenants protected, because I do. Because the information that was provided by one of our staff attorneys was simply compelling to the fact that it stated that those two individuals did not prove their case. And I stated this earlier in the private session. My concern is that if we start to say, well, you know what, if you weren't on your A game today, you didn't quite cut the mustard, we're going to let you through anyway, it sends a bad signal out to the whole law community that, you know, we don't have to do everything the law board says because they may let us slide. And that would be the reason, just as I'm not opposed to somebody having a parking space, I simply like to have more information because we're setting precedents. So for those reasons, I'll have to vote for this.
Thank you, Mr. Rush.
I would say one of the big issues that we didn't spend enough time talking about during the private session was a lot of the lack of documentation had to do with there was a leasee and a subletter, and then the subletter subdivided, and he subletted, and he subletted, which is contrary to the to where a lot of where we're wanting to go, right? And so the issues of people profiting from their leases for their lack of leases or their subleases is not the intent. We're intending to move forward with protecting primary occupants of units. And so even though the occupants there now may be primary occupants, the process under discussion, which goes back 20 years, is quite convoluted. End of comment.
Thank you. Any other comments?
I would just, in conclusion, state that, again, the people who lived in these spaces initially and testified to using them residentially were not found to be not credible. So the issue, I suppose, is one of sufficiency, which is a difficult and judgmental factor. And I think there's sufficient evidence that these units were used residentially during the window period, and they should be brought under the remedial force of the loft law, and they should be brought up to code. Therefore, I urge people to support my amendment.
I'm curious why you wouldn't make an amendment to cover the units, but not the units.
Sure. The reason I would not do that is because in this instance we have tenants who moved in within at the tail end of the window period, shortly after the vacate was lifted, who appear to be living there and paying rent, and I believe those units should be legalized and those people should be the protected occupants.
Okay. So am I understanding from the executive director that this particular, the staff actually agrees with the LJ, right?
Yes.
Okay. Ms. Rivera, could you close the board member?
Just of clarification. If the amendment fails, will the original order then be reinstated? Okay.
Somebody has to
I'm
make
sorry.
another
Yeah, so,
amendment.
oh yes, unless there's another amendment.
Okay.
Well, someone has to make a, I'm sorry.
Yes, there was a motion already and there's a second, and now we're going to vote and see if Mr. Delaney's motion amendment is approved, and then we'll have to redraft the order and vote on that.
No,
But
not
if not, we'll
redraft the
vote
order.
on the original order.
Right,
Yes,
but there still needs a motion.
yes,
then
on the original order,
On the original
Yes,
order.
yes.
Or a different motion can be posed.
or a different, or another motion,
Any
yes.
of those.
Yes, so we're first voting on Mr. Delaney's motion to amend the order.
Mr. Carver,
No.
Mr. Barnes,
Yes.
Mr. Roach,
No.
Mr. Delaney,
Yes.
Ms. Torres,
Yes?
Ms. Roseman,
Yes.
Chairperson Hinton.
No.
4 in favor, 3 against, 2 absent.
So that motion is failed, correct? All right, so is there a motion to accept the original order? Mr. Rowe? Is there a second? Mr. Carver? Is there comments on, anyone want to make comments on this, on that case?
Yes, I think the order as drafted properly reflects the current state of our rules and case law, and properly upholds the oath judge's conclusion as to coverage of 303 and 405.
Any other comments on?
Mr. Chairman, I just want to make a comment that, again, my vote in no way reflects, should reflect that I don't want to see people covered and in living in loft spaces, and that I am simply concerned that if you start saying you don't have to do this piece and you don't have to do that piece, you set a bad precedence for the whole loft community. So I'm pleased that if this passes, we would be able to provide coverage for 8 units and 8 family units that went through the process as outlined in the loft board rules. And there is still an opportunity for those other two, I clarified that in the private session, to come back around at a later time and go through the process again. So this, to my understanding, correct me if I'm wrong, in no way excludes those two individuals from coverage at some point.
It would have to be an amendment to the law.
Yeah. So just to be clear on that, right?
Okay.
Yeah, right. The Loft law would have to be amended, yeah. And I just want to make it clear, though, from my comment, that there are 8, this order contains coverage for 8 other units and at least 10 other people to be protected here. I think it's kind of an injustice to those folks not to vote for this order.
Mr. Chairman, I would just state that I believe the responsibility of the Loft law is to recognize units that are being used residentially in buildings without residential certificates of occupancy that otherwise qualify. And I think that the omission of these 2 units is a mistake.
Okay, thank you. Any other comments on this? Ms. Rivera, could you please pull the board member?
Mr. Carver?
Yes.
Mr. Bauer?
Yes.
Mr. Rose?
Yes.
Mr. Dillon?
Yes.
Ms. Torres?
Yes.
Ms. Roslin?
Yes.
Chairperson Pinto?
Yes.
7 in favor, 2 absent.
That motion, that order, the motion is passed. So we are now going to turn our attention, but before we do, to adopt board rules, but before we do, we're going to take a short proposed rule changes, and Ms. Paulson will lead this discussion.
Thank you. So based on our discussion at the last meeting, staff, I should say, I shouldn't take credit, it's staff. We all got together and we redrafted, and here is a proposal that has a lot of gaps in it, but I think it is based on the discussion that the board had. So I guess we would start with, I'm not really sure where to start. I guess, well, let's go in order. So we'll start with what would be the new section 2, which is on the bottom of page 1, where I put in a placeholder for prime lessees with the lease in effect being protected occupants to the exclusion of everyone else, if applicable. So in terms of, should that be, shouldn't that be, comments?
Given the incredible amount of energy we expended over a parking lot today, a parking space, I think it might be helpful to go through the parts of the proposal that are fleshed out and new to understand how those operate and leave the question of, it seems to me that we've been grappling for quite a while now with 2 issues, one of which is should demonstration of use of the unit as a primary residence be a condition necessary to win protected occupancy? And the majority of the board answered that question yes at the last meeting, and you've come up with a proposal here for that. The question of does a prime lessee who either has a lease in effect or had a lease in the past trump everyone else in terms of being a protected occupant? I don't think there's quite so much agreement on. So I'm more interested, so I can talk to intelligently to the people, the tenants, as to what's the impact of that which you've advanced here, rather than fight the same old war again. There'll be ample time for that down the road, I'm sure.
Okay, so we'll skip 2 and we'll go to 3, 4, and 5. Well, 3, 4, 5, and 6, I guess.
Just one last thing on 2. Helene, is there any more research being done on the the legal status of holdover?
Legal status. Can you explain that a little bit more?
Okay, last time, sorry Chuck, now we're getting into it, just so I can ask the question.
No, I understand your question.
Okay, so under the existing rule, a prime lessee still trumps if the lease is past the stated expiration date. And I had raised the point that there's probably a statute in the RPL, if not the common law, that says in effect that the terms of that lease actually still exists, notwithstanding the expiration date, if the lessee remains in possession, probably absent any notice of termination of the owner. And I thought that would create a problem. That state of the law, if I'm stating it accurately, would create a problem for your proposal, which hinges on the stated expiration date in the lease. And I said that I thought more research on that issue was needed. I thought you guys were going to look at it.
I did look at it, actually. That question, right after the board meeting, I actually went back and I could not find anything that said that. I meant to go back to see if I could do some more research, but I did not. But I did do research right after that board meeting on that issue, and I didn't see anything in the statutory law that would support that position. But I didn't do any case law research, but I did go back and take a look at the RPL, and I didn't see anything that's along those lines, no.
Okay, so if you could look at the case law for next time. In the meantime, I'm going to ask some lawyers in the know on this issue for a statutory citation if it exists, and I'll send it to you.
That would be wonderful,
Yes.
thank you.
Yeah, okay.
Okay, so section 3 just says, actually I just said this in the meeting, that if somebody is applying to be a protected occupant, they can only apply to be a protected occupant of a covered unit. So if the unit is not already covered, they must apply for coverage before we can determine whether or not the person is protected. It just makes sense to do it that way. They're not qualified for protection under the law if they're not living in a covered unit. So I'm hoping that that is non-controversial.
Except that it does happen at the same simultaneously.
It can happen simultaneously,
Right.
but it is possible. You could have somebody who is applying later for an already covered unit, in which case you just have protected occupancy. But we did actually have a case where they applied simultaneously, and we decided, and the board decided that there was no coverage, therefore they could not be protected, and those people actually went to court on that. So,
I never even realized when I went through it myself that there were two separate things. They just like rolled into one.
well, they used to all be together. They were separated in 2014 because the legislature put a statute of limitations in the law. So it did used to all be together.
This language, my only thing would be it's like that it's clear. Is this language clear that it happens together? What's before? It could be like a minute before in the same proceeding.
Well, we have a rule that says you can only apply for, that each application can only make one claim. So they would have to file 2 applications.
In the same proceeding, same oath, though? Same.
Yeah, so in other words, somebody who's applying for coverage and protected occupancy theoretically now should be filing 2 separate applications, one for coverage and one, well, nobody can file for coverage now, but assuming they could, right? One for coverage and one for protected occupancy. They should file both. It wasn't always that way. It used to be you could have multiple claims, but we decided to split it out. I don't remember what the historical reason was because it wasn't here. But it's just a question of making sure that the unit is covered before we get to the issue of protection, that's all.
Yeah.
Like, I think it's not,
No, I think in my case, it was after 2014, it was just all one thing. So I'm just confused on, I don't want to split it, it just naturally is the same both meeting, both things happen.
so the question is, do they need to file, correct me if I'm wrong, but I think the question is, do they need to file 2 applications, one for coverage and one for protected occupancy? And what I had said was that historically, people just filed 1 application, but now we would ask them to file 2 because we have a rule that says you can only have 1 claim per application.
Yes, we could do that, or we can add the 2 claims. If there's a new window period, we can add the 2 claims on 1 application form and have them check. I mean, and there would be a separate fee for, each claim, and, we could do that, right, I guess.
Is that,
I mean, they would, I mean, assuming that the 2 applications are filed together, they would be heard together. So
yeah,
that you're gonna
that's
have
all
one
I
proceeding
mean.
and then
I mean,
another
from my
proceeding. Yeah, no, they're heard
perspective
together.
as a person going through it, I didn't see it as 2 separate things. I don't even understand till later that it was 2 separate. It's,
Right.
so you're not, it's can all have, the lawyer does it and it all goes to oath at the same time.
Yes, it would all go to oath at the same time, assuming that they're filed at the same time.
Okay.
But they could potentially be filed separately.
They could be filed,
Right,
separately.
as we were just discussing in the last case, where something, if part of the application was clear and another part of the application, or if someone, for whatever reason, it benefited someone to file them separately, correct?
Yes, but they'd still have to file for coverage first. If somebody filed with us an application for protected occupancy and it wasn't for a unit that was already covered, we would tell them you have to file for coverage.
Right, that's.
Right. So.
So is that fine then, the language to just say for coverage of the unit before or simultaneous with?
Can you say that? For coverage of the unit before or simultaneously?
There's still a problem with the language.
Is it, yeah, how would you say that?
Well, obviously, if a unit is already covered, you wouldn't need a coverage application.
Correct.
But as written, it actually says you must do it, so you need to carve out for that.
No, it says if the unit in which the natural person resides is not an IMD unit at the time the natural person files the application for protected occupancy.
You got it, okay.
Right? The natural person must apply for coverage of the unit simultaneously or before, simultaneously with or before the Loft Board determines whether the natural person is protected.
Okay,
Okay?
I like that.
Can we go over that one more time?
Sure. If the unit in which the natural person resides is not an IMD unit at the time the natural person files an application for a finding of protected occupancy, there's no change there. The natural person must apply for coverage of the unit simultaneously with or before the Loft Board determines whether the natural person is protected.
Well, that's somewhat clumsy.
I'm open to suggestions.
Yeah, no, if you mean that they have to actually make 2 applications, you should say that, which it doesn't quite say that.
So must file an application for coverage.
Before,
Must file an application for coverage of the unit simultaneously with or before the Loft Board determines whether, you could say the Loft Board determines the application seeking protection or something like that. So then it makes it clear that it's 2 applications.
So why don't we just say first, like if the unit, in the first clause, if the unit in which the natural person resides is not an IMD unit at the time the natural person files an application for
For protected occupancy.
Yes. For protected occupancy, right? Yeah, take that.
Yeah.
We're taking out a finding.
Yeah.
Finding out, yeah. The natural person must file an application for coverage of the unit. Period?
Yes.
And then just take out the rest.
The problem is, it seems like you could have an ongoing trial for protection without an application for coverage.
No.
But it says before the Loft board determines whether the natural person is protected.
So you want to say before the Loft board accepts the application for protected occupancy?
Accepts or considers?
I think that's what you mean, right?
Accepts or
No,
considers?
they're simultaneously, and both are being considered at the same time, so it's not that one gets processed first and then the other starts.
Should it just be the word considers instead of accepts? For the Loft board to consider one application, they must be filed together, no? Or simultaneously, or doing two applications?
No, I think it should file it together, and both claims go to oath together.
Right.
So the Loft board doesn't rule on it until they've heard from both.
See, what could happen, right, is if the ALJ says this person has not proven their case for coverage, therefore I'm not going to rule on their protected occupant claim, then the claim for coverage comes back and the PO claim stays in advance until there's been a final determination on the board. Now, if the ALJ is recommending that coverage be granted, then she will hear and entertain the evidence presented for the PO claim. And usually what they do is that they file and they make their recommendations on the same report and recommendation. And it comes as one document, the recommendation for both claims.
That's what my experience was. So
Yes.
to cover both those situations, you may, I don't know if the word may, you may apply simultaneously or individual, I don't know.
I mean, it could be it could be that they file a claim for coverage and then they file a claim for PO, but it seems like it
I'm sorry to.
hard.
I think it needs to be drafted as a negative, maybe, that you can't file the protected occupancy unless the unit is covered or you've already,
I hate
I
drafting the
know,
negative.
or you've already applied for coverage, but that's really what you're trying to say. This is, I think the exception to that bad drafting canon.
Yeah, maybe there's a way to not go negative, but to still make it clear. I think the vast majority of people are applying both at the same time.
Right, unless the unit is already covered.
Right.
usually.
So,
I'd like to suggest that we leave it to the staff. I think we all understand what the issue is, and rather than 8 or 9 of us try to draft it,
All right, we'll redraft.
I'd rather get more to the meat, although I do have one question, which is, not on that, but in our news number 1, we established that a protected occupant must be a natural person. Do we really need to repeat natural person all those times? And are we going to go to all the rules and add 30% to our wordiology by using natural person every damn time?
I don't intend to do that, but I did it here because I thought it was important for this rule. But I can change that.
It would seem to me you've
I can just say
established
the person. I can take out the natural, right, and just say if the unit in which the person resides is not an IMD at the time of person, because we already established that it's a natural person.
Yeah.
Except that person, I think, is a defined term.
Well, if it's not protected, it's not natural.
Yeah, but I think
According to-
person,
according to definition.
But my recollection is that in the definition section, person was a defined term, and that was the problem, and that person included more than just a natural person, which is why we distinguished it here.
All right.
But I'll come up with something. But no, I didn't intend to do it throughout the rules, I just intended to do it.
The individual?
Yeah, we could do individual.
I would take out his and her, put in there. T-H-I-E-R.
Yeah, that's kind of controversial.
I mean, you know, language gets very complicated and more complicated as we go along. Rather than saying, okay, you know, it's not he, let's just get rid of it altogether.
I can redraft with that in mind as well. Okay, so 4, and 5. All right, so 4 is the loft board may find a natural person who became a residential occupant of the unit prior to the effective date of the law to be a protected occupant. If the natural person used the unit as a primary residence on, and then we have the blank. Lack of consent of the owner or the holder of the owner's interest to a sublet assignment or subdivision establishing such occupancy does not affect the rights of the natural person to protection. So this contemplates somebody that was there prior to the effective date of the law. For people that were after the effective date of the law, that would be subdivision 5. And again, it's still a question of how big do we want to make the time frame. But we never actually voted on including the primary residence. We just took a straw poll, so.
You had recommended something earlier on, months ago, in a prior draft, correct?
I had recommended, well, I have it in here, right? Hold on, I'm sorry. I need the glasses, this is very small.
Yeah, comment HB2.
Right, the date occupancy again, well, for the first, for 4, it would be during the window period on the date the person filed the application for protected occupancy, and if there is a trial through the date the record closes. That was the standard that I had recommended, which is a very long period of time. On the other hand, we have a rule that says that the board is supposed to consider the entire record, so if we shorten that, we might have to tweak the other rule, which is fine. You know, we could say, except as otherwise stated in these rules, the board must consider the entire record. So, I mean, it's really up to the board. I will say that if we go to the end of the trial period, that does place a burden on people to have to keep coming forward with proof. So you have kind of a rolling discovery, which I think is difficult. And I would recommend, if we're going to go that way, which I think we should, that we should put some parameters, some limits on discovery for the time period from the time of filing the application to the date the record closes.
That's in addition to the other window where you have to prove the 12 consecutive months?
Well, that's for coverage.
Okay.
Right? So this is all about protection.
So protection is on, we can create that or?
Yes. Yes, the law is very vague on who is protected, and the legislature left it up to the board.
Okay.
So let's talk about the start period first, rather than the end period, which
Sure.
we're going to. The effective date of the law was, I seem to recall that being one of the goalposts. I think that makes sense.
Yes.
In terms of legislative intent, in terms of parity between the owner's obligations also. So that's my opinion.
So you think the start date should be the effective date of the law? I'm fine with that.
Possibly. You, I think, go even earlier by the start of the occupancy, if the occupancy precedes the...
Well, you don't necessarily want to go back to the start of the occupancy. You have people that have been living here for a very, very long time.
Yeah.
That would be extremely burdensome, and I don't think it's necessary. I
Absolutely.
certainly would never go before the window period.
Okay, no, I was just looking at your comment, but I think in my version, I don't think you have the same version as me too, unfortunately.
Really?
But I think the date actually began is correlated to section 5, not 4. So maybe that's my
The
fault.
date occupancy began is correlated to section 5. Yes,
Okay.
that's correct.
So for 4, my suggestion to start is that the effective date of the law be the start date.
Right, it says that, right. Okay.
I honestly, I don't see, oh, it's right in there.
The effective, it's in the comment. All or some of, on the effective date of the law and the date the application was filed through the date the record
Got it,
closes.
sorry about that, yeah.
That's where it is.
It's so late, I'm sorry, I'm not seeing it.
We still got another hour.
Huh?
Chinese,
Still thinking about
tiny text.
Huh? The eye test, yeah, I know.
So effective date.
So I think the effective date of the law makes sense as a start date for protected occupancy, right? Because if that's the cutoff in terms of consent, right? So the difference between 4 and 5 is, do you need landlord consent for you to be there? And the way that the rule currently reads is, if you were there prior to the effective date of the law, or on or before the effective date of the law, then you don't need the landlord consent, it doesn't matter. And I think we should say that. I don't think that we should change that. So we would want to say, so I think starting on the effective date of the law would be fine. Or we could say prior to the effective date of the law, prior to and on. We don't necessarily have to go back very far.
Right. Now, the date the application
I'd
was...
just like to
Oh, I'm sorry.
Yeah,
register that I'm opposed to that.
okay.
Yeah.
Well, we have that now, so what's the problem with it? It's just kind of rephrased, other than the primary residence, but the start period as the effective date of the law.
I think it makes sense to, if we go this route, to say that you need to prove primary residency along with, in order to become a protected occupant. I think, as was recommended by the ALJ in the South 2nd Street case, that the date of the application for coverage leaves ample opportunity to find out if indeed it's the person's primary residence. Heather, when we were discussing this last time, you raised the question of what's the difference the day before and the day after. If you ask people to demonstrate primary residency for a 10-year period, that's where I think it gets to be very difficult. And we've seen, in the cases we've read recently, we've seen examples where someone intentionally had a different mailing address because there were mailing problems.
Right.
But if the goal here is to prevent a protected occupant from having a pied-à-terre, not using a unit as their primary residence, then it would seem to me that we safeguard that by saying, okay, when you apply for protected occupancy, you better be able to prove that at that time and going forward, it's your primary residence. And to look back now, a period of 6, 7, 8 years, is very harsh medicine to treat what I think is a problem that's limited in scope.
So the issue in the South 4th, South 2nd Street case, the oath ALJ there was talking about an end date. She wasn't actually talking about a start date. So if we went with that, your suggestion, which is that they have to start proving primary residence from the date of the application, what do you do with the whole landlord consent issue, right? Because right now, people that show that they were there on the effective date of the law, they can show that they're protected without owner consent, right? That's what the current law says. They were there on the effective date of the law. You don't need owner consent, and I think it's important to say that.
Well, as you know, at the moment, what the rule in effect says versus how the cases have interpreted things over the last 5 years, there's quite a bit of discrepancy there.
But I don't think we've veered away from that at all, right? I mean, if you were there prior to the effective date of the law, you don't need the consent of the owner, no matter what, no matter who you are, right? Whether or not you would be covered if there's a primary residence is protected if there's a primary resident But I think we've been consistent that we wanted to, that if you're there prior to the effective date of the law, you don't need owner consent to the sublease, to whatever it is, assignment, subdivision, whatever.
I have a question for the lawyers in the house. When you say effective date of the law, it's state law or not our city rules that we're doing?
It's the effective date of the Loft law, and there are several
There's so many of
iterations.
them. So
Yes.
is it the
So it's whatever-
2013, like the last time?
Whatever
the
you're
2010?
applying under, right? So if you're applying under 281.5, for you, the effective date of the law is June 21st, 2010. If you're applying under 281.1, then the effective date of the law is June 21st, 1982.
And, okay, so there's not like something, it's not the last one that was passed. Like the 2013, there was something that was, like, increased the window of the 2010 law. Didn't it? Or extended
Yeah,
it?
it changed some of the eligibility.
Like, because it would be nice if it was like the last thing that was, so that saves 3 years, right?
But the window, well, yeah, yeah.
So how is it determined which one applies to?
That they apply. The people apply, and they say on their application, here's what I'm applying under. I mean, pretty much now everybody applies under 281.5. But we could add something, what would you
So
suggest?
we can add the date there, so if you're applying, if it's a 281.5 unit, and the date that where you would have to show that it was a primary residence, if you're going to use the effective date of law, then it would be June 21, 2010. You can add that.
You know, I think having a definite date is always better, because we've had some situations when we were working on rule revisions where we had to figure out what the date was. It's like on the date these rules became effective, it's like, okay, well, what date was that? And then we had to go back and
What
look
did
through all
the
of those.
2013 rule say? Like, can it just go back to that? Well, that just was a marker of.
That just changed, it changed the square footage from 550 to 400.
I don't remember if that was 13 or 15, I'm not going to look.
Yes.
That was?
You changed the 550 to 400, and also.
And then went back.
Changed the code compliance deadlines, that I know.
Yeah.
But that's not
The 36 to 30?
the 36 to 30. So what did they do? I can't keep this straight.
I don't remember.
I have all these charts at home, in my office. I have all these
you guys know
charts
it better than
hanging
that.
on my wall.
But I'm just thinking if there was like a date that's the former versus the latter. You know, like it's years of information. It would be nice if we could, if we're going to tie it to an effective date of the law, that it's one that's closer to us.
Well, we could split it up, right? We could split it up and say, if you were there on the effective date of the law, then lack of consent of the owner, which is actually the way it is now, then lack of consent of the owner isn't necessary. And then we could have that you have to prove that it's your primary residence. So we could split that out into two separate sections, but I really think that we should save the lack of consent of the owner. Doesn't matter if you were there on the effective date of the law. I feel very strongly about that.
But then the tenant should have an obligation to prove primary residency as of that date as well, because that's who the law was aimed at, not someone who was there part-time and then picks an application date once they're full-time.
Well, that's
Yeah.
a valid point as well.
Yeah, I mean, that's an opportunity to game the system. And of course, the owner's obligations have started already on that date, on the effective date of the law.
Theoretically, owners are supposed to come in and register on their own. That's the way the law reads, and it doesn't happen that way that often, but that's the way the law reads.
The obligation has started, though, notwithstanding.
Yes.
Yeah, yeah.
Yeah.
But if there was can can someone reapply after the law changes? Like, what if you have had an application, anybody, any of these applications pending, and then the law clause revised? Can that applicant reapply on that version of the law?
So under the current proposed legislative proposal, it contains a clause that says, and I don't think this is confidential in any way, so I'm sure it's being circulated all over Albany. I hope I'm not revealing confidential information, but it does say that if you were previously denied coverage, but you would qualify because of the changes to the law, then you can reapply. In essence, that's what it says. But again, that's a proposal. We don't know what Albany will do.
What if you haven't been denied, but you worry that you might be? Like maybe you see, oh, this is advantageous to me for whatever reason, and I'm going to amend my application or withdraw it and then reapply, or just how would that all work?
We did have a case in which the person, I don't remember if they withdrew, I think the issue was that the person withdrew with prejudice. It was amendment to the law, and the owner's attorney argued that the person withdrew with prejudice under that the law that existed at the time, and therefore that person's withdrawal should be considered with prejudice and not entertained now, despite the amendment. The board found that, did not agree with that argument, and it said that based on the change in the law, the person could reapply, that the withdrawal did not bar the person. So there is some case law out there that would tend to say that if there's a change in the law, that the person could reapply.
So I guess we should get an idea of how the board members feel in terms of a start date. Should the start date for primary residence be on the effective date of the law? Let's just take it piecemeal. So, if you need a motion for that, we could just get how people feel about that. Yeah, we can get people's thoughts.
Is that your recommendation?
That is my recommendation, yes.
Who are we supposed to be imagining? Sorry, I always need clarity on this one point. So we don't know if Loft is going to pass again in Albany. If it did, the effective date would be that new
Whatever date of the new law.
The dwindling population, is there any population left that's?
Is there any what?
Population that's currently applying?
Well, nobody's been allowed to apply since June 15, 2017, but we do still have pending applications.
Pending applications
Yeah.
that are
Prior to that date.
that prior to that date.
That's coverage. We're talking about protected occupants, and people could still apply.
Oh, yeah, actually.
Oh,
yeah,
the protected
yeah,
occupants
right,
could
people
still
can
apply.
Yeah.
So that would be the 2010 unless it's the 2013.
Correct.
June 2017 or 16? I thought it was
So
17.
So if someone applying for protected occupancy only because
Right.
they can't apply for the rest,
Assuming that the unit is
we
already
start to
covered.
like really stretch out the amount of time that they have to prove.
No, well, only if they were there, yeah.
Like the burden of proof or whatever is now it's
So if that,
2010. If we take 2010, we're in 2019.
correct.
So
So let's assume,
Yeah.
let's assume somebody moved into a covered unit, some of the South Second Street people, right? So let's assume that they moved into the covered unit at the end of the window period, but they had never applied for protection, and now they're applying for protection. If we made the start date here on the effective date of the law, then yes, they would have to go back to June 21st, 2010, and go forward from there.
So our other option.
Or they would have to prove owner consent, that would be the other choice. Owner consent.
Okay. Or we have the date of application, which seems that could be
That would be
problematic.
another
Can we
state.
arbitrarily choose a date? can
You arbitrarily choose a date.
choose a date and.
You would have to have a rational basis for choosing that date.
Today's the equinox, right?
That was yesterday.
Yeah.
That was yesterday.
Like, can we choose a date though? What kind of argument do we have to make to choose a date that's somewhere not that far, not that?
How does that help?
Because I could see where you need them to prove beyond the date that they applied, but you don't want them to have 10 years of burden to prove.
There's a reason, though, why they should have the burden. It's because you don't have a landlord consent, because they just happen to be there on that effective date, and therefore they get this enormous benefit.
But
And
you
the
know, we
point
talked
of the
about.
benefit is to protect primary residence. So in order to...
Right, but we talked about this with rent stabilization. I thought it was like 183-day look back or something.
No, that's
primary residence.
No, 183 days.
There's some look back.
To keep a rent stabilized apartment, you're supposed to live there more than 183 days a year. The look back period under rent stabilization is 2 years.
2 years. Can we just do 2 years?
What would be the rationale for doing 2 years though?
That 2010 is really far away. That would be the rationale.
What Barbara just said, it is a bit arbitrary that whoever happened to be living wherever they happened to be living on the date that this law was enacted is protected, but not someone who...
No, future people can be protected in certain circumstances. We're talking about right now, this particular section we're talking about a small piece of the pie, which is those people who are seeking protection who were living in the unit on the effective date of the law, the very date that the obligations on the landlord start. So to be compatible with those, with the landlord's obligations, the tenant should have to establish its primary residency as of that date. That's who the law was intended to apply to as of that date. This is a very big benefit, and it should go to only those who were intended to be benefited.
Well, just try this out for a hypothetical. 3 of us live in a loft building. 2010 comes, it's my primary residence. 2011, I moved to California. And I'm in California for 2 years. From 2011 to 2013, it's my primary residence. None of the provisions that we have, but then I moved back. I moved back in 2014, just about the time that the board starts to evolve its new policy, which I would have had no way of knowing, right? So I'm back, but there is this 2-year period that's now 5 years in the past when I admit it wasn't my primary residence. I was living in California, but things didn't pan out in California and I came back. But now I am not going to be a protected occupant, even though I was there on the window period, on the effective date of the law, and I've been there using it as my primary residence since 2014, because there is a rule that we're putting in place now that governs behavior that applies to me from years before. What policy? It seems to me the policy we're out to accomplish is that the person who's a protected occupant going forward should be using that unit as their primary residence. And to have a, oops, you didn't know, and in 2012 we got proof, we got, you know, we have your Bay Area Easy Pass records that you were driving back and forth in 2013, and we're going to pillory you in court. What are we accomplishing?
So let me ask you something though. I mean, really this is more about owner consent and lack of owner consent. So if the person who came back in 2014 could still prove protected occupancy, primary residence, with owner consent after 2014, then I think they would probably qualify under 5.
I agree with that.
I don't think that's the way it's working over at Oath.
Well, this is why we're having a rule. I mean, right, so what do we want the rule to be? Agreed, not working that way now. Need a new rule, so let's figure out what we want, or let you figure out what you want,
Okay.
and we'll draft
So
it.
could you, so I was
So
not at the last meeting,
person's
so-
there on the effective date of the law, but they moved to California,
Yeah.
right? And they're gone for a couple of years, and then they come back. So when they come back, they move back in, and they keep shelling out rent, and that rent goes to the landlord, and the landlord knows they're there, and the landlord's very happy to be collecting that rent, right? I think that person, even though they were there on the effective date of the law, but because they had the gap, they would still qualify under Section 5, right? Because they're there with the owner's consent. Where it would be a problem would be if they went to California, and then they came back, and the owner said, well, you left, and I'm not taking your rent anymore. That would be a problem, because then they're not there with the owner's consent, and that would be more difficult.
As it should be, because they
They
left.
left.
And consent is not a lease, it's just the guy doesn't.
Well, we put in some factors that we thought would demonstrate consent. We haven't quite gotten to them yet in terms of discussion, but we wanted to give some guidance as to what would constitute consent, and, you know, you will accept or reject those, or maybe want to tweak them. They're kind of broad. We did that on purpose. So I think that that person who was there and left and came back, if they're paying rent to the owner and the owner knows they're there, then I think that they would qualify under 5. So I think that's kind of a non-issue. I think it's the person that stays, the person that's been there, you know, who's going to get the benefit of the lack of owner consent. So
So it would be as if the tenancy
began again, right.
Okay, so then back to 4.
I know what this is, that's okay.
So that's good to clarify 5. Back to 4, then if that person, that seems like a lot to bear that they would have to prove from 2010 to 2019.
You know,
And beyond.
so if they're, see, the thing is, if there's a coverage application at the same time as a protected occupancy application, then I don't feel it's particularly burdensome, because they have to prove window period occupancy anyway, right? So you're already looking back that period of time. The question is it unduly burdensome to prove after the window period? And I think that that's something we could fashion in terms of what documentation, once they prove something, and maybe that's the answer, right? So on the effective date of the law, they prove that they were there, and then they have to, you know, supply something that shows that they continued in the occupancy, and we can tailor what that is. And maybe that would make it less burdensome, right? If they didn't have to produce every bank record and every tax return and every voter registration or whatever, right? Maybe then that would, even though it's a longer period of time, it would be less of a burden. Does that make sense?
Yeah.
And maybe that's the solution. But of course, then we gotta figure out what it is that they need.
Even like taxes, you only have to stay on for 7 years, for example, right?
My accountant tells me I should save my returns forever.
I
But I can throw out the proof.
Well, I have a new guy, and he's more conservative than my last person, and he told me 7 years.
7 years.
Yeah, I mean, I think that's what the law is.
Personnel and
Yeah.
taxes.
You could conceivably create milestones, so as an analogy, in zoning, if you're trying to establish that you have a grandfathered use from the 1930s, so the building department is not requiring you to show a photograph of every day of the year for the last 100 years. They'll accept proof at certain points in time. So perhaps as this period gets longer, you could establish milestones similar to a grandfather use concept. So maybe that's one idea for a long period. Keeping in mind that the occupant is getting a very large benefit. some amount of proof is not unreasonable to
Right.
make sure that primary residency actually exists.
And the 2-year idea doesn't appeal to anyone? 2-year,
It doesn't appeal to me, but
to be more in a lot, like, doesn't make any sense.
It's
If
not
rent's
correlated
stipulated.
to the policies that the statute is getting at.
So is the idea, let's say the effective date of the law and the date of the application, as those 2 dates that the person would have to show that the unit was their primary residence?
so then the person who went to California and came back, that would be okay because they're back. So I don't know that that would be a terrible thing if they moved to California and came back.
So
That's
those
a problem for
circumstances,
owner
they could
consent.
be,
It's a problem for owner
Or owner
consent.
consent.
Yeah, because once they're gone,
but they would still be under what?
But under-
In my hypothetical,
Yeah,
maybe I wasn't
my-
even the one, maybe I was just chipping in and somebody else was paying the rent, and I'm not a prime lessee.
Well, then you're not there with owner consent, right? If you're just chipping in for the rent, you're not actually paying the rent to the owner, that could be. I mean,
why is that person being elevated once the person leaves? I don't think the intent of the legislation would actually run to that person.
I mean, right now, there is no prime lessee, and you have 3 people who are occupying the space. All 3 people get protection. There's no prime lessee, and all 3
Right.
people were there prior to the effective date of law, for which consent is unnecessary. All 3 get in. All 3 get protected.
If there's no crime.
There's no prime lessee.
What if there's does that mean a prime lessee is not trying for coverage, but they,
yeah. They're gone, they moved on, there never was one, I don't know, it could be many permutations.
so if we did, what was the milestone idea be, what would those be? You're saying that if it affected just 2 days?
Well, I don't know,
Or is there
no, I
something in the
don't.
middle? Something.
Huh? Any window periods?
I mean, I could see you wouldn't want someone to move back in and make it their primary and then make an application and then cover when they were
Gone.
yeah, but,
I don't know, I am leaning more toward keep the period longer, but tailor the proof. I feel that that's fairer. Because then you still are covering the entire period of time and you're not picking target dates. Because target dates are easy to manipulate. That's sort of what I'm thinking. But the board can reject that.
does the tailored proof, my last question, does the tailored proof really reduce it in a case? Or I thought there's cases where they make them like ad nauseum, like keep proving.
Well, but that's the whole point. That's why, that's one of the
We could
reasons
stop
that
it?
we're discussing it. Yeah, we could stop it. The board could put in a rule about discovery in this situation, right? Just addressing the protection situation and tailor discovery. And oath's procedural rules say that if the agency that's referring the case has a rule, that rule takes precedent over the oath rules. So if we tailor a discovery rule here, then oath has to follow that.
That assumes we have legal authority to actually redefine primary residency, which we might not have.
Well,
I read the Court of Appeals case differently from you, which is what I'm driving at.
right. Both you and Chuck read the same case differently from me. Yes, I do understand that, and that is something that we might have to deal with. But I think in the interest of fairness to everybody, we should at least try. That's what I think.
Try to what?
Try to tailor something that will work for the loft law, for loft law owners and loft law tenants. And just to go back to Manhattan, Lower Manhattan loft tenants, the case says, I don't have it, I have it here somewhere, but, you know, the case says, you know, unless it has that extra clause that says, you know, there could be other policy reasons why you would want to do something different. So I think we have very different policy reasons. For one thing, it's a retroactive law. Rent stabilization looks forward, we look backwards. That's a big difference. So that's my take on it. So if you want to go that way, that's fine. We'll try and draft something. If you really feel that you want the milestones, then we'll try and come up with milestones. We'll take a look at the grandfathering provisions and see what they do in terms of that and try and put something in. I'm not that familiar with it.
That was an off-the-cuff thought.
Yeah, but it's nice to have.
I don't know that it's the right way. I don't know.
And it could maybe be taxes, but within.
I don't know, you know, I mean, no, just tax returns? I don't know, because, you know,
not every tax, just one.
Yeah.
1 year, that's somewhere 7 years.
Or one document for each year, maybe?
Well,
right?
It's just the 2010 one seems hard to prove now. Even myself with a whole server of photos, it gets harder to find those photos from, you know, years ago.
Right.
And that would even, so I'm just wondering what you would show from 2010 if you don't need to have taxes saved from back then and you maybe don't take photos. What would you have?
Well, you could always
Why
have.
do you need it? What are we trying to accomplish here? Mr. Carver keeps talking about the huge benefit that this law has, and for somebody who's recently covered, where their rent is pretty much close to market rate, I don't know how huge it is. He speaks of when the owner's obligation begins. I'm not so sure of when it begins. I think we get further and further afield from what are we trying to accomplish here.
If it's not a benefit, then they wouldn't be applying. We're trying to establish primary residence.
We're trying to protect people who are using their units as intended, I think, as their primary residence. That's who we're trying to protect. That's what we're trying to accomplish. And how do we figure that out? I'm not saying it's easy, but I think that there are different ways that we could approach it. So I kind of like the one document for each year.
Yeah, that seems like too much.
Okay, what seems like too much?
Yeah. What if it was like
the
two?
milestones?
I had to use disability once, and I had to prove
It's not
they.
a terrible thing.
Yeah, I know. I had a health issue, and I had disability insurance, and it said they looked back at 5 years of what I made, but I had to have 2 years simultaneous to like establish what my disability would be.
Right.
And so I'm wondering, like, if you had a look back where you don't have to show every single year, you just have to show like 2 in a row or something. You know, like taxes from 2 years, look back. Forget the effective date of the law, because that's like too far back. I don't know what they can show from 20.
Well, I don't know. I don't know that it's too far back, and I think that the South 2nd Street tenants, when did they file? I mean, they filed in 2015, so they were going back 5 years. They managed.
5 years is within the, let's use 7 years for taxes as some kind of benchmark, maybe, that people are accustomed to, but.
Somebody said that is the law, right?
I think that is the law.
That's the law, yeah.
It might be up to something, maybe that is a good benchmark.
Because I just think it gets harder to.
From the application date? Yeah, 7 years back from the application date. I don't know.
You know, you guys on staff really have to think hard about evidence, because this notion about one document per year, that's a problem, because think about evidence. you want various things to be pointing in the same direction.
Yeah, I understand what you're saying.
One thing isn't going to do it, so you really got to think hard about evidence if you're going to limit it.
Right. I just threw that out as an idea. I do understand what you're saying.
I feel like Julie might be onto something with the 7 years in the tax, because I like stuff that's founded in some sort of law out there, some sort of precedence that only exists.
Well, doesn't it seem a bit of a stretch to say that you have to show primary residence for 7 years because that's how long you have to keep your taxes?
Well,
I mean,
no, I'm not saying that we should.
We're not saying-
we could pick the expiration date, the 2 years that cough medicine is good for until it's best by use by date.
It kind of vilifies, if there's already a precedence. I mean, I'm not hard and fast on it, but I'm just saying there's already a legal precedence that says 7 years is recognized by the IRS as the amount of time you have to keep something. I'm not saying we need to word that in here, but if it becomes in question, there's precedence there that shows that that's a benchmark for.
You know, but can I just say, if we use the 7 years, right? We would be going, and the last application was filed on June 21st, 2017, which was the last application date at this point. It would be 7 years. Right, from June 21st, 2010 to June, almost 7 years, to June 15th, 2017. That would be 7 years. And then the question becomes, well, do they have to go past that to when the record closes? So I think we already have that 7-year period built in by the way that everything worked out. Obviously, if the law is amended and we're going to have a new window period, nobody's going to have to go back past 2015, right? So then that issue kind of goes away.
Right, I just don't know how many of these protected occupants are applying right now.
Tenants right now are approving window period occupancy, so they're going back 10 years. So the same proof that they're using to prove coverage is the same proof that they're using to prove protected occupancy.
Right,
so I don't see any 7 years. They're already going back 10 years. Some of them are going back 15 years. We got proof in South 2nd Street from 2004.
So you're saying
the proof is already there.
It could already be 2000.
It's already there. Whether if the proof is there, it's there already without a 7-year limitation. They have to prove today. I mean, back in 2007, they're proving a window period from 9 years ago. We got to it around now, but they're already doing it.
Wait, who's doing it?
The tenants.
Where there are simultaneous applications for coverage and protected occupancy. For the people that are trying their cases now at oath, to get coverage, they're already going back to 2008 and 2009 because they have to show coverage, right?
Right, but those are guys doing it simultaneously, and we're done with those cases. Like you can't be that case anymore.
Well, we can't accept applications, but we're still deciding cases, right?
Her point is that it's possible and it's happening.
How many are still in the system?
This, I think, somewhere around 50. Don't quote me on that.
50 since the 2017.
Yeah, I had those statistics at the end of your report, and my vague recollection is that it was somewhere around 50, but I would have to look at it.
And how many protected occupants separate roughly from doing that combined?
I don't know. We can get those numbers for you.
Because, I mean, I understand if the new law passes, the new login in 2015. In 2025, they'll have the same conversation we're having now.
But I hope we can tailor a rule that'll be flexible enough that we can never have to discuss this again. This is extremely painful.
I mean, I know what Bobak's saying, for those 50 cases, those are, that they have this long burden, they're just doing it. That's their only option, yeah. But for the protected occupant who might come from any, is fewer of them, and they might come from any time period.
Yeah, much fewer. It's definitely much fewer.
So. we're just trying to make sure that they live there
Look,
as primary.
if you're in
Yeah.
occupancy on the date of the law, which is the population we're talking about, in order to get, you'd have to have a combined application. There would be no such thing as protected occupancy application now that coverage is over, right? If it's not covered, that's it. So,
No, but you could have somebody applying for protected occupancy for a unit that's already covered. We had
Like a roommate or
couple of cases.
a husband or wife.
but
Like we had a case earlier in the year where the occupant was killed in a war and then somebody else moved in and the owner alleged that there was a sale. And the new tenant, we found that the new tenant was a protected occupant because they moved in with the owner's consent and there wasn't a sale.
okay, but
So-
we're only talking about this narrow universe of people who are in occupancy on the date of the law.
For section 4, yes.
Right, and I
Yes.
thought that's what our
Yes.
conversation was limited to.
Right.
So coverage would necessarily need to be simultaneous because you're not already covered if you're seeking protected occupancy under 4. No?
I don't know. I mean, I think somebody could have been there. What do you think about it? So let's assume you were there, but you didn't seek protected occupancy at the time, for whatever reason. And the unit became covered. And now you want to be a protected occupant.
So is there coverage through means other than proof by the tenant?
Well, it could be proved by another tenant. Right? Let's say that there were 2 people living there, right?
I see.
And one person applied for coverage and protected occupancy, and for whatever reason, the second person didn't at that time.
I see, yeah.
And the first tenant is covered and protected, and now the second tenant comes and says, I want to be a protected occupant too. That could happen.
It could, yeah.
Right? Yeah.
Mr. Chairman, would I be out of order if I suggested that, given the hour of the day, that we task the staff with taking our discussion today along with their abilities and coming back with 3 options?
Oh, no, we're not doing options. No. No, please, don't make me do options. It's really hard. It's really hard to have a discussion, nobody knows what we're talking about, it's just a mess. So, no, I think we could come back with more information.
Well,
Okay, that we could come back with, about milestones or suggestions as to what documentation or something like that. That we could do, but not another draft.
would I be out of order if I said that she
I take that just to say that we're all tired and want to take a break here.
Either that or Mr. Vera has to go get some coffee.
Well, actually, the other problem is we don't have the room for much longer.
Yeah. Let's see.
Yeah.
So researching possible milestones.
What
For
milestones
number
would look
4.
like, or documentation, limiting documentation or something like that.
And considering the fact that we're 9 years from the date of the law.
Yeah, I have to say, I'm not that sympathetic to that argument, but yes, we'll consider it.
It's almost a decade, I mean, that's like.
Yeah, I understand that, but you're bringing this claim and you have certain things that you have to prove, right? So
With the digital aid.
And again, you don't have to worry about the people who are 9 years out, right? Because they've already filed, they can't refile.
Right.
I mean, those people are already out.
If there was another round, then, like I was saying,
Yeah,
a
going
decade
forward.
later, it's gonna be the same conversation again.
Okay.
For them, it would just be good if there was So you're gonna redraft number 3. Number 4, you're gonna look into milestones options.
Yeah, we'll look into milestone
Number
options.
5,
Number 5 we sort of didn't get to, but
Going on consent.
5 will sort of follow what happens, I think, in 4.
Touched upon it a little bit.
Yeah.
I have a better idea. I think we should task Michael Bobbitt to come back with his
There you go.
Yeah, before he leaves, so make sure he gets his stuff.
One final.
Yeah.
We should let him go until we pass.
Do we have any possible idea of the new legislation in Albany, whether it's on the agenda to be,
It
is
is,
there a date where it may go through or?
my
be
my
voted on?
understanding is that it is in committee in Senate, and it's going to stay there for a while until certain concerns are satisfied. That's my understanding at the moment.
History repeats itself, June 21st, 2019.
June 21, 2019, let's hope not.
This will conclude our March 21st, 2019 board meeting. Our next public meeting will be held on Wednesday.
No, Thursday,
Thursday.
sorry, my typo, Thursday, no more Wednesdays. I
Good.
promise.
This will conclude our March 21st, 2019 public Loft Board meeting. Our next public meeting will be held on Thursday, April 18th, 2019 at 2 p.m. right here at 222 Reed Street, Spector Hall. Board members, please sign, hand in your attendance sheets, and we say goodbye to Mr. Bobbitt.